division. Um, I was going to start off with the required rulemaking portion of it. So back in December, I had brought 4 issues that affected 5 different sections of our rules. And the first was R647-1. So that is the minerals definitions. And we had to change to the definition of basalt so that it would match the statute change from a previous legislative session. The next rulemaking issue that I had brought to you was a well workover tax credit. Our rule said that an operator had 90 days to submit paperwork to receive that tax credit. And there was a change in statute during a previous legislative session that added an independent CPA to be involved. And that resulted in the workover tax credit forms to be submitted late or incomplete. And so this rule change just changed the deadline from 90 days to 180 days. Another rulemaking change was the comment period for UIC wells. Our rules currently say 15 days, but the EPA requires no less than 30 days. So we had to change that comment period to maintain primacy over the UIC well program. And then lastly, we changed our rules on the Form 10 submissions to match what we're actually doing in the office, which is just submitting it electronically. So all of these rules, I had submitted them back in the middle of December. They've gone through the required 30-day comment period, and none of them received public comments. So the reason why I'm bringing it to the board today is I need to file a notice of effective date, which I'm suggesting as today, February 23rd, 2022, so that we can get those in place. So once I get confirmation of that, then I can move on to the legislative update.
So Natasha, you're asking for an action by the board right now to
Yes.
give you consent to file that.
Yes.
Board members, do you have an opinion on that? Is there any problem with supporting what she's asking? Hearing none, I think that would be fine. Please go ahead.
Perfect. I will do that after the briefing session. And then moving on to the legislative update. So this has been a fairly busy year for the Division of Oil, Gas, and Mining. Just kind of as an overview, we're monitoring 57 bills that affect the division, the board, and our employees, and that's out of 752 numbered bills. And there's still new bills coming out every day. And right now we have 5 bills that directly impact the division. So the first one I'm going to present or notify you on is House Bill 244. This is geologic carbon sequestration. And this bill will allow the division to apply for primacy of Class 4 wells. John Baza has spoken in support of the bill a couple of times, and it's been moving smoothly through the process. And it's currently on the agenda for the Senate Natural Resources Committee meeting tomorrow. The next one is House Bill 378. This is titled Mining Operation Amendments. And this is a relatively new bill. It was introduced last weekend. The intention behind the bill is to allow landowners to move rocks off of their land and to sell them. We're currently working with the representative to find language that works for all parties included and doesn't end up negatively impacting the division. We had there's a substitute that was released yesterday that would remove basically all mines from being regulated by the division. So we were working pretty closely with the representative yesterday. We think we've come up with really good substitute language. And that's actually the bill that Dana Dean is speaking on this morning. It's actually currently being heard in committee. So you should be receiving an update in my Friday email on that bill. The next one is House Bill 435, another mining bill. This one, it's another relatively new bill that would require the division to approve a notice of intention for small mine operations that are located in a Class 1 or a Class 2 county. The fiscal note has been received for this one, and it has yet to be assigned to a committee meeting, but this is one that we're watching pretty closely. The next bill, this one is also being heard in the same committee meeting as the mining operations one. This is SB 146, and it's titled Division of Oil, Gas, and Mining Amendments. This moves some tar sand operations from being regulated by our minerals program to being regulated by our oil and gas program. So if the tar sand comes out as a liquid form, our oil and gas program would be the one to regulate it. This one has also moved smoothly through the process. And again, it's being heard in committee today. And then lastly, Senate Bill 97. This is solid and hazardous waste amendments. And this one addresses E&P waste facilities where they had to get gubernatorial and legislative approval to operate. This bill removes that requirement, but it still requires DOGM and waste management and radiation control regulatory permitting and oversight. This bill has actually passed completely through the process and is being prepared for enrolling. And with that, I can answer any questions that you may have. And if there are none, then I will turn my time back over to Director Baza.
If you don't mind, Natasha, I'd like to comment briefly on one of those bills. Senate Bill 146, which Natasha mentioned, it changes some exemption language that's in the statute right now, because there are companies who want to go out and essentially do in situ steam recovery from tar sands. As the statute reads right now, that is exempted from our oil and gas program. But in other states, such as California, that's a very common practice to extract heavy oil with enhanced recovery through steam. So we feel that it is a better fit for our oil and gas program than our minerals program to regulate that. So that is all the bill is doing, is allowing that one particular application of technology to fit within our oil and gas program.
Board members, do you have questions for Natasha on the matters that she has presented?
Natasha, do you know what time the Senate hearing is, or the committee hearing on 244?
Let me hurry and find out for you. That is something that I should have looked up beforehand.
I can answer Levon. Yeah.
John Bosner.
It's scheduled for 8 o'clock tomorrow
8 o'clock.
morning.
Thank you.
Any other questions? Well, thank you, Natasha. I appreciate that update.
Yeah, of course.
Thank you, Mr. Chairman and members of the board. And thank you, Natasha. We appreciate your efforts in this regard. There's a couple of other items that I'll bring up to you that are kind of issues we're following very closely. You may have read news reports recently of the division's enforcement actions involving Alton Coal. We had some bonding concerns come up that started in the October timeframe. And as we worked with the company to try to replace their bonding, it was taking a long time. So we actually earlier this month issued a cessation order to the mine saying that until they had that proof of adequate bonding in place, that they were to cease actively mining coal. Now, it didn't shut them down completely because it allowed them to continue with reclamation operations, to remove coal from their stockpiles. They just could not actively extract new coal. That was in place, like I said, earlier this month. And as of last Friday, the company did provide adequate evidence to us that new bonding was in place. So we lifted that cessation order so that now the mine is able to actively move ahead with its operations. And they should be back in business at this point. So I just wanted to give you that update because no doubt you've seen some news reports on it in the last few weeks. The other item I wanted to bring up as under other items goes to the bill that Natasha mentioned, House Bill 244. It is the carbon sequestration bill by Representative Handy. And wanted to let you know that that does involve future action by this board, both in rulemaking and in adjudication. But this is going to be the start of a very long marathon race. It's going to stand up a new program. The current regulation of Class 6 CO2 injection wells in the United States is completely under the control of the U.S. Environmental Protection Agency. But there is an alternative that they allow for states and tribes to seek a primacy delegation from EPA as long as the state's program can be as effective as what the EPA has in place for regulation. In order to do that, we needed some statement of intent by the legislature to say that was appropriate for the state of Utah to seek that primacy delegation. It's similar to what we do in Class 2 injection right now. And very honestly, CO2 injection occurs as a Class 2 injection if it's part of an enhanced recovery project. So this won't change any of that. People will still apply to the division and the board for enhanced recovery projects and CO2 injection, as they always have. But if it involves CO2 sequestration and storage, it falls under this EPA regulated program. So what the legislation will do is allow us to start the application process, which we understand from other states could be on the order of a 2-year process of back and forth discussions with EPA. But at some point down the road, we would have the authority to regulate CO2 injection under that Class 6 primacy delegation. And that's when this board would have to develop rules. That's when this board would have to start adjudications and approvals on new projects that are being considered. So there's a lot of work to be done ahead of us. This really just gets us out of the starting gate. So I'm happy to answer any more questions you might have on that, but I thought you ought to know a little bit more about why we think this is a pretty good idea.
Board members, Steve?
So John, is there a case where other states have been given primacy at this point by the EPA?
There are only 2 states in the U.S. that have successfully navigated through that process. One is North Dakota, and for various reasons, they were the first one out of the box. So it took them about 7 years to obtain that primacy. Wyoming was more recent, and they managed to do it in about 2 years, but it's my understanding they're still trying to finalize specific regulations to meet with EPA's approval.
Okay, Director Baza, do you feel that the HB 244 provides you sufficient resources in order to do a good job on this process?
Very honestly, Mr. Walker, we indicated a higher fiscal note than what the bill currently has. Fiscal notes are the creation of the legislative fiscal analyst, and we can only be advisory in that process. But the fiscal note that we indicated was substantially larger than what is on the bill at this point in time. But it is a start, and we'll work with what we get in order to try to do as much as we can. But it's clear to me that we'll likely have to go back to the legislature in future sessions and ask for additional support as we get farther down this road.
Mr. Baza, what happens with projects that would be proposed between now and when rules are promulgated? Are they able to go forward, or are they on hold?
If they wanted to go forward before we actually develop a program, they can apply to the EPA even now.
Okay.
But I think from what we're hearing from specific developers is they would rather work with the state rather than the federal government.
Thank you.
Any further questions, board members? Well, thank you for giving us the update on that particular piece of legislation.
Mr. Chairman, that really concludes our activities for briefing this morning. We will have another regularly scheduled board meeting in March, and we'll look forward to that, and we'll look forward to closing out our reports to you of legislative actions that have taken place. So I'll turn the time back to you now, sir.
Thank you, Director Baza. We typically take this opportunity to accept public comment on matters that are not necessarily related to the issues we're going to be hearing during the briefing portion of our agenda. Julianne, do you know if anybody had submitted comments electronically or wish to comment electronically other than, for matters other than the docketed items?
No, Mr. Chairman, we have no general comments. We do, however, have many who would like to comment on the tree farm matter, and I have notified them that that comment will take place during the tree farm proceedings.
Thank you. That's appropriate. Any members of the public that are here today that would wish to comment on matters not related to our docketed items, if you have those comments, please come forward. Seeing none, we will conclude our briefing session of today's hearing. We, as the board, will take just a few minutes to discuss a few items before we start the formal hearing portion of our meeting today. So if you'll excuse us for 5 or 10 minutes, well, at least 10 minutes, we will come back and go on the record for the agenda, for the docketed items. So we'll be back.